Well, let's talk about it. Everyone may not agree with my take of legal insanity or using it as a defense. Let me bring in my guest. I've got with us Dr. Daniela Schreier. She joins us from Chicago. Where is she? Do we see her? There she is. Dr. Daniela, great to see you. Also with us is Sunny Hostin. She joins us in New York, our in-session legal analyst and contributor. And here with me in studio is Bob Rubin, who was the attorney for Hemi Newman, who also claimed legal insanity. Great to have you here.
Thank you.
Great to have everyone here. Bob, let me start with you, though, because I am a little bit on the attack here. Okay. And from my experience, right, as a prosecutor, my experience here on In Session is that many times when the experts for both sides don't agree and we go to trial and people like Hemi Newman claim legal insanity, it's because they have nothing left, because they can't say he or she didn't do it. So they got to come up with something. So, all right, let me find an expert who'll say, my guy was insane.
Your question kind of assumes that we create the defense, that the defense lawyers create the defense. And in fact, I don't think that's true. What we do is we take the facts and we analyze them, and then we talk to people, experts in all different aspects of the law, and we ask them their opinions about the case. And many times, we just go where the experts or the evidence leads us. If the defense is accident, we go that way. If the defense is, I didn't do it, some other dude did it, we go that way. In insanity cases, you have to have an expert. You can't put up insanity. You can, but it's unusual to put up insanity without some forensic psychiatrist or psychologist telling you, I've examined your client and he's insane. In Hemi Newman's case, there was no question he did it. We knew that. But we still had to look to see why he did it. And that's when we turned to the experts. And we had very credible experts, Tracy Marks and Adriana Flores, who evaluated Hemi Newman and said, I have no problem testifying that this man was insane at the time of the act.
All right, let's turn to our expert. We have Dr. Daniela with us. Dr. Daniela, let me ask you about this. Finding someone insane or determining whether or not they're insane. I'm always skeptical of the defense when it's at trial. Always skeptical about it because not everyone agrees. What do you think of this issue? Do you think that if experts are disagreeing that there is a possibility that this person is actually insane, or should it be so obvious to an expert like you that, you know, everyone agrees, prosecution and defense agrees? Because that happens every day in courtrooms across this country.
Well, that's the best scenario. And I do think also we have a legal concept of insanity, and someone can be not insane. Insanity, all that it means, right, that you have to prove that at the time of the crime, your defendant did not know right from wrong. That's different from mental illness, because we have many people who are mentally ill, but yet did know and even premeditate a crime. Remember the old case of Andrea Yates. We know she had a long-standing, terrible history of mental illness, schizophrenia, she was hearing voices, etc. Yet she was found guilty, but mentally ill. So this is actually, and the insanity defense, did not go through. So I'm agreeing with you in our case at this point that the defendant doesn't have any existing mental health history. And later on, I think also that the prosecution very well demonstrated that she could be found guilty on both accounts of her charge. And so I do think in many cases, insanity, yes, it's very obvious. And the best case scenario is when both sides can agree.
Let me bring back in my guest. Dr. Daniela, let me ask you about being clearly convinced that someone didn't understand it. How would the interview, I guess, by an expert like you go? What are the questions that you ask? How do you figure out, from your perspective, whether or not this person understood the criminality of their conduct?
Well, the challenge itself, Vinnie, is that you have to go back and establish what was going on back then. And that's always very difficult. And what we said before, if you have a person with a long-standing history of a mental disorder, and actually Illinois, the statute requires a substantial disorder of mood, behavior, or thought, then it is much easier if they would have hallucinations or delusions, because then you could say, well, they were hearing voices, or they were, as the lawyer before said, on a steroid, etc. And then it's possible that they really did not appreciate right from wrong. So this is where it would go. It is very difficult always to prove what happened in the past. So this is the sort of questioning. And you would really look for mood disorders that are mood disorders or thought disorders that are having a long standing, and you would look for hallucinations and things like that, or pervasive cognitive disorders like even Alzheimer's, etc., where someone really loses the capacity. You have to differentiate that as well, because people say, well, I was drunk, but we know, right, in the court of law, you were drunk. Alcohol, you still are responsible. So this is the questions that we have to figure out, and I don't think it is very easy for an expert or to come forward and say, well, we go with the insanity defense, because it takes a lot of time and preparation and work and assessment. And even in the case that we discussed right now, the expert did not come forward and declared her actually that she was insane. He just said she had an adjustment disorder, which is a very lightweight diagnosis, and we don't know what she was adjusting to, okay? He also said that she had some processing difficulties. I'm not sure what cognitive assessment test he gave, but that doesn't mean that she was not cognizant of what was going on. And in her case, as a forensic or even clinical guy, you go back, Vinnie, and you assess, well, at one point she approached a person for a letter. Can you please give me the letter that you just gave me the donation, because as a matter of fact, I needed the money, not because I was actually sick. Or at one time during the long period, she shaved off her eyebrows. This is clearly premeditated in order to lead people on that she is sick. So all these things is actually what we are looking for before you really come forward and make a case for, yes, this person could clearly meet the standard of legal insanity.
You know, and you look at the history that this defendant has. Is there a history of mental illness? Not really. There is a history of lying, at least according to one of her exes, who's going to be on In Session a little bit later on today. You don't want to miss that.